here. This is actually, I'll have to say, that one of my favorite events and favorite speakers that we have in the program of this semester. This is Judge Wood, a judge at the Federal Court of Appeal for the Fifth Circuit. Seven. Why do you think fifth?
Because I clerked there.
See, that's the danger when you set up a foreigner to run your Center for International and Comparative Law. They think they know the world, they don't even get the federal courts right. That's my problem. Fortunately, you don't have to listen to me very long. You can listen to our speaker, Judge Wood. The topic, of course, she'll speak about international law and domestic courts is one that we hear a lot about and hear a lot of views of different degrees of sophistication, both from practitioners and from scholars. The very attractive thing about Judge Wood is that she's actually both. So she's been a professor at the University of Chicago Law School for a long time. She's been an associate dean there, in fact. And she's been a federal judge for a long time, for 13 years now. She was a professor before for international law at Chicago. So she really knows about these topics from both sides. And when you read her opinions, you can tell that she actually has that expertise. I will not say much more about this, except she will speak for probably around 30 minutes, or substantively less or substantively more, we'll see. And then we'll have a question and answers period after that. And remember, before I forget, on Wednesday, Jean-Marie Henkarts will come and speak about international humanitarian law. Jean-Marie Henkarts is one of the co-authors of the big report on international humanitarian law, authored by the International Red Cross, and that has caused a lot of controversy on the role of customary international law, etc. in there. So that'll be a nice continuation from today. But for now, please, Judge Wood.
Thanks. Well, thank you very much, Ralph. Thanks to everyone here at Duke. It's a real pleasure to be here. I was just reflecting that the last time I was at Duke Law School is so long ago that none of the buildings that you're now sitting in were here. I think it was in the late 1980s when there was a conference that I attended. But it's a real pleasure to be back, and I'm most impressed. What I want to begin with is something that may be painfully obvious to all of you, except that it is not painfully obvious to many, if not most, people who sit on the federal bench. And that's important for you to know, because if you are ever writing a brief, if you are ever trying to present any kind of argument that has anything to do with international law, you need to know your audience, right? And so the first question is, what are we talking about? What's international law? Not many judges could tell you that Article 36 of the Statute of the International Court of Justice offers a list of recognized sources for international law. And they might kind of say, well, it has something to do with treaties, and they certainly don't know what customary international law is. They're not at all clear on that. So let me offer a few thoughts just in that very preliminary way. You know, how are international norms created? Well, they're created, as you know, in all sorts of ways, even very informally sometimes through actions of private organizations, when international custom builds up to the point where you would be justified in calling it law. National laws also sometimes create a consensus on particular points. In Europe, for example, if you're arguing before some of the European courts, you might find the European Court looking to see whether all of the member states have evolved a certain way. Examples of this include an area in which I'm quite interested, what international people would call competition law, what we would call antitrust law here. There are no end of articles written these days on the topic whether there is now an international norm against hardcore price-fixing cartels. Some people think maybe there is at this point. Other people think maybe it hasn't quite ripened yet. We don't know. Laws relating to the internet, capital punishment is something which I see you're going to have a program on right away. There are all kinds of norms that are growing up out of national laws. Secondly, of course, we do have the entire field of treaties and other international agreements. And I'm going to come back to that because the Supreme Court has just heard arguments in a case that's very interesting from the point of view of treaty law. Treaties, as you know, are part of the supreme law of the land, and you might think that that A tells you what a treaty is and B tells you what legal effect treaties have, but you would of course be wrong. First of all, not all things that are considered treaties or international agreements really go through the formal processes of negotiation by the executive branch, advice and consent by the Senate, ratification by the President. Just to give you a very good example of something that I think we would all recognize as a treaty is the World Trade Organization Agreement. It didn't go through that process because Congress had given the President what it called fast-track authority. The whole thing was negotiated with all of the countries that were, at that point, members of the General Agreement on Tariffs and Trade, and it was put before both houses of Congress and enacted as implementing legislation. No advice and consent, no treaty formalities. But it's certainly an international agreement by anyone's definition. Well, what do you do with executive agreements? What do you do with other kinds of, let's say agency-to-agency agreements? The Securities and Exchange Commission has agreements with counterpart agencies in many countries that are also regulators of national stock exchanges and markets in which they work together to address questions of market fraud. Well, those things are certainly not advice and consent kinds of treaties, but they are definitely international agreements, and if you ask people who've been prosecuted with information collected through these procedures, they would probably tell you they are agreements with some teeth. So the question of what are treaties is actually quite an interesting one, and what status they have in U.S. courts is something I want to come back to. It depends on a number of factors. The third is this customary international law. You can find Supreme Court decisions that say this is part of our law. You can have elaborate debates these days, and there are scholars on both sides of this question, whether after Erie Railroad against Tompkins, there is such a thing as evolving customary international law with the abolition of general federal common law. The Supreme Court's 2004 decision in Sosa against Alvarez-Machain seems to me, anyway, to suggest that the court does think that there is some customary international law. It sets some fairly high bars for what might be enforceable, at least under the Alien Tort Statute in U.S. courts, but it doesn't seem to me to be saying that there is no such thing. And I can talk, if anyone has questions about this later, about what I think one would need to see in order for customary international law to be enforceable in a U.S. court. Now, I want to make a couple of comments once we've kind of decided what international law is, because, as you perhaps know, there have been some fairly passionate debates in recent years about whether U.S. courts should even be paying any attention to this somewhat esoteric body of law. And I have found those debates regrettable in many ways, since they have swept, in my opinion, with far too broad a brush. There are many, many ways in which international law is used routinely in U.S. courts, and it's completely uncontroversial. No one that you can think of would have the slightest complaint. So take the Warsaw Convention, which is the convention that tells you how much damage you're going to get if you suffer personal injury or if they lose your suitcase forever on an international air flight. It was Justice Scalia, in a separate opinion in the Olympic Airways against Hussein case, who said we should be paying attention to what the other parties to this convention think about the meaning of certain terms. What's an accident? What isn't an accident? Was at issue in that case. It was a treaty. No question whatsoever that this was a treaty that was enforceable in U.S. courts. So, you might think of Justice Scalia as somebody who said international law doesn't belong here, but that's way too broad. He doesn't think that. Nobody thinks that. Another unfortunate aspect, I think, of the current debate is that it has lumped together international law in the sense that I was just talking about it, and foreign law. Absolutely different things. Foreign law is just the law of some other country. And we deal with questions of foreign law regularly in the courts. I can recall in my own experience needing to take into account French corporate formalities in deciding whether a particular income tax credit was due. And we had all sorts of expert testimony and people translating the French legal texts and so on and so forth. And that was the dispositive question. We've had questions of Egyptian law. You have diversity cases where choice of law principles might point you to the law of another country. Routine. No one is saying that that shouldn't happen. And I can give a few other examples too. These are all, I mean, kind of random really, but the point is there's so many. In 2004, in the antitrust area, the Supreme Court decided a case called Hoffman-LaRoche against Empagran, and the question there was whether foreign purchasers of vitamins could sue, like your vitamin B, could sue members of a cartel that had unlawfully fixed the price of those products worldwide. Now, the cartel's actions certainly harmed the U.S. market. The cartel was operating in the U.S. market. But the problem was the plaintiffs were foreign purchasers who had bought their vitamins in foreign countries. And they wanted to leverage the fact that there was some U.S. harm over into their ability to bring a lawsuit. And the Supreme Court's opinion rejected that effort. There's a statute called the Foreign Trade Antitrust Improvements Act. The court looks at that statute, kind of works its way through. It's one of these midnight statutes that gets into quadruple negatives and things like that that make it very difficult to construe. But the court essentially says, look, we aren't the only actors here. There are other countries with competition laws. If we expand our law so far as to cover these actions by foreign purchasers for injuries they suffered in foreign markets, we will have transgressed one of the fundamental principles of international law, essentially, which is that jurisdiction in the sense of competence is allocated around the world. Okay, it's a very interesting opinion, and I recommend it to you. Another context, again, that you've probably heard about since the day you were taking civil procedure is forum nonconvenience motions. If you're dealing with foreign countries as an alternative place to bring a lawsuit, one of the things the Supreme Court has said you have to evaluate is whether there really is an adequate alternative forum in that other country. Probably the best known case was not a Supreme Court case. It was a case dealing with the question whether the litigation that arose out of the terrible chemical accident in Bhopal, India, should be litigated in the United States against Union Carbide, which is a U.S. company. You can bring a lawsuit against a U.S. company in the U.S. But to use the phrase, the center of gravity of that litigation was not in the U.S. It was in India. That's where the accident happened. That's where the people were injured. But the Indian courts, actually, we had a bizarre phase for a while during that litigation in which the government of India itself was arguing that the Indian courts could not provide an adequate alternative forum. They changed their mind actually later and said, yes, they could. But the Indian courts had never dealt with a case of that kind of magnitude. There was real concern that it would just go on so long that there would be no effective remedy. Now, maybe some of us who followed the U.S. courts might think that that sometimes happens here, too. Your dean has some experience with how the asbestos litigation has gone on. But nonetheless, that evaluation had to happen. And the Supreme Court in 2007 decided a case, again, reinforcing this method of analysis called Sinochem International against Malaysia International Shipping, where the question was U.S. courts versus Chinese courts. The court said belongs in China. So, there can be political differences in system and the like, and there still might be a forum nonconvenience dismissal. And, I could go on, but the point is there are many, many completely uncontroversial settings in which international law and foreign law will be applied. Now, there are other settings in which it is more controversial. And I would have said that there really is one primarily, and that's when it comes to construing the U.S. Constitution. I think it's no accident that some of the greatest passion has come about when the question on the table has been, what does the Eighth Amendment require? What does it really mean to say something is cruel and unusual? And is there any place in the debate for international opinion, international law? Some justices think, no, this is U.S. law. The people who wrote the Constitution weren't thinking about that. They don't like the idea that the Eighth Amendment has evolved anyway. Other people think, as Justice Ginsburg puts it, a decent respect for the opinions of humankind suggests that it doesn't have to be dispositive, but you ought to at least know. Are you going to be an outlier out there with North Korea and have the whole rest of the world against you, or are you really going to go into the mainstream? So that's one of the really controversial areas. Interestingly, another one I think is well illustrated by a case that I'm going to say a few extra words about that the Supreme Court just heard argument in October the 10th, the Medellin case, Medellin against the state of Texas. That has to do with who gets to interpret treaties, for example. And I'm going to go into a little bit of detail about that, but first I'm going to tell you an anecdote from very early in my own legal career where, oddly enough, this same issue in some ways came up. And as far as I know, it just faded off into some remote corner of someone's filing cabinet. When I was a very young lawyer at Covington and Burling, I had just joined Covington and Burling, having been at the legal advisor's office of the State Department for a period of time, and our client was a drug company. And there is a convention called the Single Convention on Narcotic Drugs, which was that particular version. There had been earlier conventions, but that was entered into in 1961. It was amended in 1972. The United States is a party to the Single Convention. Many, many other countries are parties to the Single Convention. And the Single Convention creates a regulatory regime for what it calls narcotic drugs. And essentially the way it works is that there's an organ of the United Nations called the Economic and Social Council. They have a specialized commission that decides under what schedule should various dangerous drugs or mind-altering drugs, or whatever you want to call them, drugs, be placed. And the commission schedules these drugs according to advice received from the World Health Organization. The World Health Organization studies them and decides what it wants to do. So there'll be a Schedule I drug, a Schedule II drug, a Schedule III drug. And our client was manufacturing a drug in the United States that was under Schedule III. Now that is a kind of drug that doctors, it's a prescription drug, you can't buy it over the counter, but doctors can give you a prescription for a Schedule III drug that you can refill as often as you want to. And the World Health Organization had received information, rightly or wrongly, I haven't any idea, but they had received information suggesting that this particular drug was more dangerous than that, and it needed to be upgraded to a Schedule II drug, which means the doctor, you've got to go back to your doctor every time you want to refill. So you want codeine, for example. Well, your doctor can't just give you infinite refills of codeine. And they thought this substance needed that. So our client came to us and said, what are these people in Geneva doing telling us that we have to move our drug into this higher level of regulation? Because what bothered them was that the Food and Drug Act of the United States, in part, implements the Single Convention on Narcotic Drugs. And I'm going to read you the language of the relevant section that so infuriated our client. It says this, it still says this: if control is required by United States obligations under international treaties, conventions, or protocols in effect on October 27, 1970, which is a fancy way of saying the Single Convention, the Attorney General shall issue an order controlling such drug under the schedule he deems most appropriate to carry out such obligations without regard to the findings required by subsection A of this section and without regard to the procedures prescribed by subsections A and B. Well, the criteria is a long list of criteria. Is it safe? Is it efficacious? What have you done? Have you jumped through all these hoops? So all of that goes by the wayside. If the World Health Organization recommends to the Economic and Social Council this thing needs to be moved from Schedule II to Schedule III, this statute says we will just do it, never mind all the rest of these procedures. And interestingly, actually, lots of the litigation brought about this has been brought by the organization NORML, the National Organization for the reform of marijuana laws. But the authority has been upheld, and I haven't really seen much of anything about that, but it's the very kind of delegation of U.S. regulatory authority to an international body that is now coming around again in a very different setting in the Medellin case. We had advised the client, we don't really think there's much you can do. We'd gone to the State Department, we'd met with people, and I think they finally, in the end, acquiesced to the reclassification. So what's the issue in Medellin? Medellin is the last in a line of cases, maybe not the last one, but the current one on the table in a line of cases that deal with the Vienna Convention on Consular Relations. And the Vienna Convention on Consular Relations is one of those conventions to which the United States is a party that is supposed to assure that people's consulates can work in different countries, will be able to get protection for U.S. citizens, foreign nationals in the United States will be able to get their own protection. And the problem has centered around Article 36 of the Consular Convention, which is the article that says if you're arrested, then the arresting authority must notify you that you have the right to contact your national consulate. And further, if you so request, they will make that contact for you. So in other words, there are two things. First of all, you have to be told by the authorities that you have the right. And then secondly, the authorities don't contact the consulate on their own. They contact the consulate if they've given this initial notification at your request. And to put it kindly, compliance with that requirement was really spotty in the United States for a long time. Police in any jurisdiction you want to, from little tiny towns all the way up to state police to everybody, would arrest people, and it just didn't occur to them that they were supposed to do this. So there were all sorts of people who were foreign nationals who were arrested, who got the regular rights that are provided for by U.S. law. They were told they had a right to a lawyer, they got their Miranda rights, they got all of those kinds of things, but they did not get this extra Article 36 right. And Article 36 has language at the end that some people think suggests that this is an individual right. And it also says that member states to the Vienna Convention have to give full effect to the rights described there. So there have been lots and lots of cases about this, and last year, in a case called Sanchez-Llamas against Oregon, the Supreme Court, in an opinion by the Chief Justice, decided that whether or not Article 36 gives right to an individual right of action was beside the point. It said we don't have to decide that question, because they said even if it does give rise to an individual right, this is not the sort of thing for which a suppression remedy or quashing of an indictment is appropriate. So we're just not going to enforce it that way. There are other ways that it could be enforced diplomatically and so forth, because what Mr. Sanchez-Llamas wanted was to have the whole thing essentially thrown out on an exclusionary rule type basis. All right, in the meantime, before the International Court of Justice, and you have to realize up until fairly recently in covering these cases, there was a thing called the optional protocol to the Vienna Convention on Consular Relations, which said that the United States consented to the jurisdiction of the International Court of Justice to adjudicate disputes under the Vienna Convention. So Mexico espoused the claims of 51 of its nationals in particular cases before the International Court. It's called the Avena litigation. And the International Court decided that they did have individual rights and that it was up to the United States to figure out the details of a remedy, but at least as I read the Avena case, they said you have to do something that's effective to give these people reconsideration of their claims before you go on and reject them, because the Vienna Convention, most of the people were on death row, most of the people had what we would say procedurally defaulted their claims. And so one of the people was Mr. Medellin, and his case went back to the Texas Court. Oh, well, the other thing I should interject, because this is very important to the Solicitor General, then the President did two things. One, he issued a statement saying that we were going to comply with the International Court of Justice's decision, and that he wanted to do so by having the state courts reconsider, just essentially open it up again, give a new hearing on this Vienna Convention point. So he did that, and then more or less in the next breath, it might have even been a few days later, but he withdrew from the optional protocol. But he made it very clear that the optional protocol did cover the case that had gone all the way to judgment while we were still party. So Mr. Medellin's case goes back to the Texas Court of Criminal Appeals, and the Texas Court of Criminal Appeals says, we're not going to reconsider this case. It's procedurally defaulted under Texas law, and the president has no authority to tell us that we can do it. There are all sorts of problems with that. And besides, we don't really think the United States can be bound by this adjudication, since it seems inconsistent with Sanchez-Llamas to us. So there are a lot of questions that have arisen out of this. I think it's quite interesting to look at the briefs and the transcript of the oral argument. One of the questions is not unlike the question in my single convention on narcotic drugs case. The Supreme Court is grappling, clearly, you can tell by the questions the justices were asking, with the issue whether once the Supreme Court has interpreted Article 36, now this international tribunal has interpreted Article 36 in a way contrary to the Supreme Court's. Does the Supreme Court have to yield to that other interpretation? That's one way of looking at the question. Lots of citations of Marbury versus Madison. It's emphatically the province of us, to say what the law is. It's not those people off there in The Hague, and so on. So that's one issue. That's a way of looking at the case. Another way of looking at the case, and I guess I might have even brought this out more than the lawyers did, but what the lawyers said is this isn't really about the underlying interpretation of Article 36. This is about the dispute resolution procedure and the duty to give effect to a judgment. And I think there are a couple of things that you see Justice Ginsburg getting close to this, saying, isn't this a little bit like full faith and credit? Well, of course, the simple answer to that is, well, it's not really like full faith and credit because that's in the U.S. Constitution. What I would analogize it to is arbitration agreements. The United States is party to countless treaties, to friendship, commerce, and navigation treaties, to bilateral investment treaties, to treaty after treaty, in which we agree that if a dispute comes up between the United States and another party, could be a government, could be an individual, we'll arbitrate it. Well, the court, I think if they had spoken more in the language of arbitration, the court might have seen better the distinction that the petitioners were trying to draw, because it's well known in arbitration that when a court is reviewing and deciding whether to recognize and enforce an arbitral award, you aren't reevaluating the underlying merits of the case. You are doing something different. You're asking, was there an agreement to arbitrate? Was this within the scope of the agreement? Is there some overriding public policy reason why you should refuse to enforce, notwithstanding the fact that the other two things are fine? The Solicitor General, I think, described that quite well in his argument in the Medellin case, as the court is essentially saying, what are you telling us? We have no power anymore if there's an international agreement? He said, absolutely not. He said, you have two really important functions here. Number one, ascertaining whether the International Court of Justice had jurisdiction, and actually that was pretty much conceded because we were parties to the optional protocol, and as was Mexico. And number two, would there be anything unconstitutional about giving effect to the ICJ's judgment? Is there an affirmative prohibition in the Constitution? And he argued, he placed a great deal of weight on the fact that the president had said that as a matter of his foreign relations power and the like, it was in the interest of the United States to comply. The petitioners didn't think that was so important. But interestingly, it was trying to focus the court on very meaningful provisions. The Chief Justice was throwing out hypotheticals to the effect of, well, what if the ICJ just said, that any police officer who fails to tell someone about his Article 36 rights is automatically in jail for 5 years? Well, clearly, that would be unconstitutional. That would be imprisonment without due process. I don't think the court would have any problem with striking that down. So anyway, what are you going to look at? Are you going to look at the underlying interpretation, in which case the court seems very hostile to the idea that we have delegated that interpretive function to some international body, or are you going to look more particularly at the enforcement of the judgment? So there are actually other issues. I mean, there are a whole lot of other issues. If you like structural issues, every single one of them, as the state of Texas points out, is there. What's the role of the president in lawmaking versus the Congress and the courts? What's the role of the federal government versus that of the states? Can the federal government compel the states to override a rule of procedural default that's a state rule? Can the federal government dictate state court procedures? Can the federal government commandeer state judges to do something in a case like this? And on and on. There are really many issues, but I think the case itself is a very good illustration of an important question of international law that is before the Supreme Court right now that will tell us a lot about how international dispute resolution is going to plug into U.S. court proceedings in the future. One of the justices at the argument, I think it might have been Justice Breyer, pointed out that the United States, as I said a minute ago, is party to lots of conventions and bilateral treaties, multilateral conventions, in which we promise to participate in dispute resolution before various kinds of international bodies. And if the Medellin case comes out in a way that suggests, well, actually, we're not going to comply unless we feel like it, there's a cost to such a decision. You can say, well, there are diplomatic solutions in that case, and there are. And if you think that's enough, that's a way you could interpret this. But it's a very important case for the way that international law is going to fit in to our domestic procedures. And so I think with that, I would welcome any questions. I think pretty much anything you want to ask, I'm willing to take a stab at, as long as it's not before the Seventh Circuit. Or the Fifth, for that matter. Yeah, right. Well, I'm from Houston, so that's... Some people say, how did you get to Chicago? Yes, ma'am.
I would like to know what's the difference between an individual arguing in a federal court based on the international treaty, and the direct effect in the European Union law.
Sure. In European Union law, as you were saying, there's a doctrine that says that certain kinds of community enactments have what's called direct effect. So if it's a regulation, it doesn't have to be mediated through a national legislature. The regulation is just there. An individual has the right to rely on that regulation. So a good example is the regulation in the competition law area saying that you can't have anti-competitive contracts. An individual sued for breach of contract can say, this is a void contract because it violates Article 81. So fine. The analysis in the United States is more complicated because first you have to ask about any treaty, was that treaty self-executing? And self-executing, when I say that, means is this treaty something that contains enough detail and enough, I guess it's complete enough that it stands on its own 2 feet. It doesn't need Congress to implement any additional legislation before it can take effect. Now, the Vienna Convention, at least in this respect, is conceded to be self-executing. It's no matter what side of this you're on, it's thought to be a self-executing treaty. Then, though, the next question is very similar to a question that you'll encounter in any statutory setting, in this instance treaties being a lot like statutes, is whether, even though it's self-executing, that treaty gives rise to some kind of individual right. Sometimes, only the Attorney General is supposed to enforce things. Sometimes things are simply not addressed to a class of individuals. So you have to ask that. And the argument that's being made in the Consular Convention is that this convention is all about government-to-government relationships. It's designed to address the diplomatic function between governments. And yes, there's this little detail in Article 36, but it's really all in the because of this bigger thing. Other people, including, Justice O'Connor and others, have rather strongly opined that at least Article 36 does give rise to individual rights. And it's actually quite interesting that the court has always found a way not to decide that. They don't really, at least so far, they haven't wanted to come out and say they're not there. Maybe they'll do that sometime, but they haven't done it yet. So is there an individual right? Unlike statutes where we often will have an express private right of action, well, then you have to have a right of action. You have to have rights, you have to be able to be the one suing. And unlike statutes, which very often actually have section something or other of the statute that says individuals, the federal courts will have jurisdiction to hear cases by persons injured in their business or property or whatever, treaties aren't likely to do that. Treaties are almost always in the area of trying to see if there's an implied private right of action. And the court has not been very welcoming of implied private rights of action in recent years, but they exist sometimes, and so the court would look at the structure of the treaty and the like. So I think the bottom line answer to your question is it's probably more complicated in the United States to make a decision about whether a treaty has what you're calling direct effect. In Europe, there are, it's spelled out in the treaty, which things do. If it's a directive, it probably doesn't, even though there's some squishiness at the edges for that. But a directive is something that the member states have to implement. So with the benefit of having created their treaty in 1958 and forward, I guess they were able to be a little bit more precise. Yes.
I'm not from the U.S., and I'm just a bit surprised by the fact that here we are discussing whether the U.S. should enforce its international obligations. And I'm surprised, how can Texas just say, we disagree with ICJ, and we don't, Texas is not a subject of international law. The U.S. is, and U.S. has breached. And how can, is there any way that the government in Washington can force Texas to respect international law and the judgment of the ICJ?
Well, what I would say is that the position of the United States has been that, of course, the United States itself is a subject of international law. We have constituent units, and if they fail to comply with something, then the United States itself is in breach of its obligations. People who think the courts aren't really the right branch of government to be dealing with this, I believe, would argue that under, I think it's Article 94 of the UN Charter, your remedy is not necessarily to have the government in Washington tell the state of Texas something, although I'll come back to that in a minute. You can go to the Security Council, you can do different things if you meet, some people think it has to be like a breach of peace, but in any event, there are diplomatic ways in which breaches of international obligations get resolved, and those people think that. Now, I think the state of Texas itself was a little uncomfortable with such an uncompromising position, because at the very end of its brief in Medellin, it says there are all sorts of other things that could happen that would be consistent with our obligation to enforce the ICJ's judgment. So it says, for example, the Congress could pass a statute amending what those of us who deal with it every day call AEDPA, the Anti-Terrorism and Effective Death Penalty Act, which puts very strict restrictions on federal habeas corpus, particularly second and successive petitions. But what Congress imposed in AEDPA, Congress can also change. And so the state of Texas said all Congress really has to do is say, this is an instance where these people who are, like Mr. Medellin on death row in Texas, can simply go to the federal district court, file for a federal writ of habeas corpus, raise the ICJ's opinion as a new and intervening law, and obtain federal habeas relief. Well, they're right as far as that goes. Congress would have the power to do that. The question is that necessary, not is it sufficient? So another thing, one of their weirdest suggestions, I have to say, frankly speaking, was they had this concept that maybe the president could, by executive order, establish some kind of commission staffed by retired federal judges who would evaluate each of the 51 claims. Actually, some of them Oklahoma has now evaluated, but the remaining claims, we'll say, and decide in each individual case whether the failure to notify that person of the consular notification possibility created any prejudice. And so then the state of Texas says, well, and for those cases where they think there is prejudice, the commission would then notify the state pardons and parole board and would urge them to take, respectful consideration of this finding of prejudice, and through the pardon and parole power, give effect to the ICJ's judgment. And it had a couple of other suggestions too, but the thing that interested me is to come to that at the very end of this brief, which is a very tough line brief that essentially says we, the state of Texas, are entitled to rely on our procedural default rules, even though the ICJ very clearly said you can't. You have to give them a new hearing. Didn't prescribe the outcome, of course, for anything, but just said, we don't care how you do it, but you have to find a procedure that will work. I think there was a concern at the end of the day that they needed to show that there was at least some realistic possibility. Now, of course, the petitioners and the United States all take the position that you don't need extra laws and you don't need extra procedures, because the fact that the United States was a party to the convention, a party to the optional protocol, and that the president took the position he did are already all the legal basis you need, not to mention that we're parties to the UN treaty and all the rest. But the first thing I think you have to separate out is what's the violation, what's the remedy. If the U.S. itself has violated international law, the remedy might be for other nations to do something, at least in theory. If there really is a violation, but if you really wanted to do it, you probably could pass emergency legislation. Now, of course, the only problem with that is these are death cases, and in an earlier round of Vienna Convention litigation, the U.S. Supreme Court refused to stay in execution of somebody while the International Court of Justice was in the process of trying to adjudicate the claim. The guy was executed in Virginia, so later on is not necessarily going to be satisfactory. Yeah.
It's great to have you here.
Nice to see you, yes.
Would you agree, because if you don't buy the premise, then my question doesn't get off the ground, but would you agree that Medellin is a very hard case as a matter of law in many different ways? Because it seems to me it's split. It's not liberals versus conservatives, but liberals against liberals, conservatives against conservatives, right? And it just seems to me, why decide the case? It's an extraordinary set of facts. We've already withdrawn from the optional protocol, right? There's any number of ways in which the court can get it wrong because it's such a difficult. Why decide the case? Why not just dismiss it as improvidently granted?
Well, I agree with your premise. I think Medellin is a very difficult case, and the more I study it, the more issues I see that need to be done. And I have to say, after what I've read so far about it, which is basically just the briefs and the transcript of oral argument, and I've had cases under the Vienna Convention, I'm nervous because the thought of the Supreme Court coming out with a decision that says, essentially, we actually really don't need to give effect to judgments in a particular person's case. That's why I like the arbitration analogy. Not in a precedential sense, as the court said in Sanchez-Yames. The ICJ doesn't even regard its own prior cases as precedent, so there's no reason why we should. But when A versus B has been adjudicated, and then we say, well, we've decided we're not going to give that any force, it's very troublesome. The United States has a huge presence in other countries in the world, and looking at it from that very broad perspective, my guess is that's why the president thought that we should comply with the judgment, that the proper way to do it, if you didn't like the optional protocol, was to withdraw, but as to things that were governed up until that point, it was to comply, and that's what General Clement's argument essentially says. But I don't know. I mean, it'd be awfully hard. I guess they can dismiss as improvidently granted whatever they want to, but if you look at the criteria of Rule 10, they are big issues. So I don't know. Yeah.
In more routine day-to-day applications in federal court of areas of law generally controlled by the states like contract and court, do you ever find resistance to the imposition of international law based on federalism?
Not really. I mean, I'm trying to think of the way it comes up. It can come up in a couple of different ways. Certainly if it's an international contract, the parties might not have realized that there's a convention on international sale of goods, and all of a sudden here's this federal law coming in through, this is a bona fide treaty, negotiated, advised and consented to by the Senate, et cetera, and it displaces ordinary state contract law, and it does allow you to opt out of it, but if you don't say anything, and there it is, all of a sudden you have international law. We've had some cases under the CISG, and people who aren't as sophisticated are sometimes surprised that it's there. The other area where I see the kind of overlap you're talking about actually is in recognition and enforcement of foreign arbitral awards. But we have a system that's pretty much like the New York, it's Chapter 2 versus Chapter 1 of the Federal Arbitration Act, or Chapter 3 if you're in Latin America. So I don't see too much. I guess I would have to know exactly where international law was intervening in one of these things. Yeah.
I have a general question about international law in the constitutional context. If, as you've said, we use international law in all these different contexts, the question shouldn't be we don't use it. It's, how do we determine when we're using it? So how do you explain, or what do you think about, the arguments that people make, criticisms of Kennedy's use of international law in, like, Roper or other constitutional settings? There's sort of this reaction, like, we don't do that here. I'm going to go eat my freedom fries now. What can be done, or could happen that would make international norms, what's going on in the world, more part of the American constitutional vernacular?
Well, it's an interesting question. I have to confess that I was not one of the people pouring my Bordeaux, down the sewer. I didn't see the need. Or certainly not the justification. But, I think Kennedy thought very carefully about it. It's very interesting because it's just a little tiny section of Roper, and it really could have begun, and by the way, because it's after a long discussion of what's happening in every state and how things have changed over the years and all of that. And I guess I would love to see this put in better context, because my own feeling is that the court, of course, is entirely correct. At the end of the day, the interpretation of the Eighth Amendment is for the Supreme Court to make under our system. I'm not interested in going back and revisiting Marbury or anything. It's for the Supreme Court, and they should decide that. But they do look at all sorts of sources when they decide difficult questions like that. Probably some people who are on this faculty might hope that maybe sometimes they read a law review article. I don't read them as often as I wish I did, but I certainly, if I'm looking at an area that's particularly difficult or that I'm not as experienced with, I might take a look at a few articles and just sort of see what kind of thinking is out there. How are people posing the questions? Have I really remembered to look at everything that matters when I decide this question? And I would say, and I've heard Justice Kennedy himself say this, that looking at foreign experience, this is not really international, this is foreign law that we're talking about, but looking at foreign experience can provide the same assistance to your own thinking process. Maybe they've had some experience with something that we haven't seen yet, and you might think, wow, I didn't realize that was a possibility out there. Maybe I need to write the opinion in a more careful way. Maybe I need to circumscribe what I'm saying. Maybe I write more broadly, whatever it is. But just as a law review article can help you, even though you're certainly not bound, by what Professor Carrington said or by what anybody else said, you learn from it, and I think that much ought to be acceptable. Now, I'll give you two other perspectives. One person who I have had the privilege of getting to know over the last several years is Margaret Marshall, who's the Chief Justice of the Supreme Judicial Court of Massachusetts. And Margaret is now sitting on an advisory committee of judges that the American Society of International Law has put together, looking at these very questions, the kinds of things we're talking about today, international law in the courts. And it started out as a group that had one judge from each circuit on it, and I was the Seventh Circuit's person. But we decided, or it was decided, I'm not sure who decided it, but somebody decided that it was really important to include the state, a few state judges on this as well. And Margaret burst out laughing as we were in the middle of this discussion, because she said, the law of Illinois is not binding on Massachusetts, or the law of California or anything else. She said, we state Supreme Courts are constantly looking at other people's experience as we encounter questions that may not have come up before. And it's not because of a full faith and credit mandate. It's not even in the case, but they look for enlightenment. Courts of other countries look for enlightenment. You can see it in any country you want. It's really not just cherry picking. I understand if you're going to say, well, everybody thinks X, and you put down a list of 25 countries when there are more than 190 members of the UN, that's disingenuous. You shouldn't do that any more than you should say all scholars agree with X if in fact there's a split in opinion. I have no use for that, and I don't think anyone else does. But that's not what Justice Kennedy was doing in Roper, for sure. He lined it up quite accurately, I believe. And as for another objection I've heard, Justice Scalia, for example, at a debate before the American Society of International Law said, well, if you're going to do that for juvenile death penalty or death penalty of mentally disabled people, why not do it for abortion? Well, why not do it for abortion? I don't have any problem with that. It seems to me that would tell you something too. I don't think one ought to be results-oriented about these things and pick some issues that are worthy of checking out, what's going on in the rest of the world and others that aren't. But I think it's the fact that if you even say the words out loud, you've somehow breached some conspiracy of silence is I think, a real shame, since I don't think it means that you are beholden to what others have said. It just means that you might learn something and then take it back home, plug it back into what you have. You might reject it because you might say, our system simply doesn't permit taking that factor into account. Fine, Yes?
You were saying before that sometimes courts will recognize and enforce customary international law, and that we could ask you what kind of standard the courts require. So I was just wondering if you could...
Sure. Well, the first thing you have to figure out is what counts as customary international law. And the line of cases that has addressed that most comprehensively in recent years are the cases that have arisen under the Alien Tort Statute. Because the Alien Tort Statute, 28 U.S.C. Section 1350, specifically says an alien who suffered a tort in violation of the law of nations, that's customary international law, or a treaty, may sue in the U.S. courts for a tort. In Souza, the court said there has to be a very broad degree of consensus, and it identified what I think of as the Blackstone Three, safe conducts, injuries to ambassadors, and something else, I forget the other, a very narrow set of things. But other courts since then, there's some interesting Ninth Circuit cases, Sarai against Rio Tinto Zinc, which the Ninth Circuit took en banc, in which they said, well, the court made it very clear in Sousa that this was not a closed set. It's just hard to win acceptance into the club. But they thought that violations of what international lawyers would call jus cogens, or however, depending how much of a Latin purist you are, jus cogens, those norms they thought might fit this as well, because in order for something under international law to have that status, there has to be an extremely broad consensus. The international system has always recognized that you might need to leave a little room for truly a rogue state that's just not with it. But so unanimity is impossible to ask for. But that's the way the court seems to be going. Now, the other thing you see with customary international law, there's an interesting separate opinion that's always been one of my favorite opinions in the international area in the Sabatino case, the Bank of Cuba against Sabatino, written by Justice Harlan, in which he explains why the active state doctrine has to be regarded as federal common law. Now, that's not quite the same as saying, not the same as saying it's customary international law. But he is looking at the way that countries are supposed to interact with each other, and it's a step away of saying that certain jurisdictional and competence allocations do flow from a fairly customary recognition of where lines start and stop.
I have a question, actually.
All right.
I have lots of questions, but I have one. So much of the discussion on the role of international law seems to concern a very narrow area of international law, as I said at the beginning, and mainly that seems to be human rights issues broadly understood, including the right to consular assistance in the international. So could it be that the debate is not so much about international law, but really about this specific area of international law, and might it help in the discussion to focus just on that, instead of the broad discussion on sovereignty concerns, federal concerns, etc.?
Well, I think it would help. I mean, that's my view, although trying to think, there's been litigation from time to time over, say, expropriation provisions in treaties, some of the economic rights areas, I don't know whether you want to call that human rights or not, but economic rights areas. And the United States has been a little bit cautious about the international human rights treaties, in that things like the International Covenant on Civil and Political Rights, while it's something that the United States has accepted, the Senate at the same time said this will not give rise to an individual right of action in U.S. court. So they wanted to keep it, I guess, in a sense, as a command to Congress, to the executive, to whatever, but no individual rights. And there have been two somewhat conflicting reasons for doing that. One reason is we already do all of this anyway, so why do we need to complicate matters by having everybody cite the convention at the same time as they're citing, 1983 or whatever they're citing. But of course, we don't do all of it anyway. The death penalty is a big sticking point in the United States. There's no consensus on the Supreme Court to say that the death penalty as a whole is so inconsistent with the Eighth Amendment when so much in the Constitution actually refers to capital punishment. So I think at the end of the day, we do know that we are not completely following these conventions, but we don't want to be outside the club either. And it might help to focus this. This is my sense, that this is really about constitutional law, and to some degree it's about human rights law. You're not seeing people worrying about either international or foreign law in many, many other applications. And if we focused and said, let's get some helpful scholarship on what we should do in the areas where it's really causing problems, we might make some progress.
The thought along the same lines, it strikes me that the resistance to the use of international standards with regard to human rights issues has to do with the role of judges in American culture. And there's a lot of resentment out there today about excessive claims on the part of as to the wisdom of the judiciary in dealing with these deep and profound issues. And it's not hard to see that when a judge is out there reaching around the world and saying these are human rights matters that are worldwide, you are claiming to be exercising responsibility for imposing natural law on on people who think of themselves as having a right of self-government. And that's it seems to me the profound conflict is people resent being told that they don't have any choice in these matters. And if judges are willing to say it's natural law, it's international law, then there's nothing more we can do about it. We can't amend the Constitution, we can't do anything. You've just claimed to solve all the problems associated with this issue, and we resent it.
I think that's right. I mean, and that's why it is particularly constitutional issues, because, if Congress, when we signed the international covenant that I just referred to, the Civil and Political Rights Covenant, had passed a statute, just like they did with the World Trade Organization, and they said, this is the implementing statute, and then judges were applying it, people would say, well, if Congress repeals the statute, it repeals the statute, or if it does something else, that's okay. And so I do think you're right, that the fact in our country, and we don't even have the tradition of parliamentary supremacy, however much that's truth and however much that's fiction, that they have in the United Kingdom. Parliament, in fact, the House of Lords, I believe, claims that there are some things that it has decided that are so fundamental that Parliament really actually can't overturn them. But, what that list is, I'm not positive, and I'm not sure that they could tell you, how they figure out what's on it. But yeah, certainly if you look at the civil law countries and you look at other countries where the judiciaries play quite a different role, you don't see the kind of passionate debate. And those countries have much more experience with international institutions. Certainly the Europeans do.
Also likely to have a more explicit text. The German basic law will
Right.
deal with all these issues in a much more elaborate way. And for somebody to say, well, the Eighth Amendment commissions the Supreme Court of the United States to decide all these questions is a bit of a stretch.
Well, they decided in Trope Against Dulles that it evolves, so I guess, which I think most of us are content with.
We're all content with that. One thing first, that the issue of public international law in domestic courts versus private international law in domestic courts is actually a topic that the Duke Journal of Comparative International Law will have a wonderful conference on next semester. So I'm very glad that Judge Wood mentioned how relevant this subject is. And of course we'll try to get it back then, but that might be very hard. We've learned a lot. We've learned far more than just the role of international law. We've also learned that it's different the role of foreign law, and we've learned that even different is the role of law review articles by Professor Carrington. You can get enlightenment from all of those. We got a lot of enlightenment today. And let's have a hand of applause for that.
Thank you very much.